Now, are you an active member in the Catholic Church?
Yes.
Okay. So you're aware that murder is considered a mortal sin?
Murder is a mortal sin? 7 words, 1 question. And a Massachusetts courtroom went dead silent. This is the moment nobody saw coming in the trial of Lindsay Clancy, the nurse and mother who strangled her 3 children with exercise bands before trying to take her own life. She's admitted she did it. That was never in question. What's on trial now is something far more complicated. Was she in her right mind when it happened? And this week, a prosecutor asked a question so loaded, so calculated, that it stopped the entire proceeding cold. Let's back up, because to understand why this moment landed like a grenade, you need to understand what's actually at stake here. In Massachusetts, this isn't called an insanity defense. It's called criminal responsibility, and the distinction matters more than you'd think. In most states, the defendant has to prove they were insane. Here, it's flipped. The Commonwealth has to prove, beyond a reasonable doubt, that Lindsay Clancy was of sound mind when she killed Cora, Dawson, and Callan Clancy on January 24, 2023. Not just that she did it, that she knew what she was doing, and that she was capable of understanding it was wrong.
The same pretty much from the start. She admits, yes, she did kill her kids, but she argues she's not criminally responsible because she wasn't of sound mind at the time. Now, in most states, this is known as the insanity defense, or not guilty by reason of mental defect or disease. In the Commonwealth of Massachusetts, it's criminal responsibility. Lindsay's team says she was suffering a mental break at the time, stemming from postpartum psychosis. And based on the Commonwealth statute, that's true. The entire burden of proof is on the Commonwealth here. Not just the usual, did she do it, burden of proof. No. The Commonwealth must prove beyond a reasonable doubt that Lindsay Clancy was criminally responsible because she was of sound mind at the time of the killings. The defense is giving its all to show that Lindsay was not of sound mind at the time. And for that, we've heard from Lindsay's friends, family, medical experts who evaluated her.
That's the legal battlefield. And for weeks, the defense, led by attorney Kevin Readington, a man who moves through this courtroom like he's playing 3-dimensional chess, has been building a case that Lindsay was drowning in postpartum psychosis, misdiagnosed, over-medicated, and failed by nearly every system that was supposed to catch her before she fell. Before he called a single witness, Readington made a move straight out of the defense attorney playbook, a motion for a required finding of not guilty, arguing the Commonwealth hadn't even cleared the bar to keep the case alive. He didn't win it. Judges almost never grant these motions. But he made the record anyway.
And let me also say, before any defense witnesses were ever called, Kevin Readington tried to have the entire case thrown out altogether.
My suggestion to the court is that the evidence that's been presented on this case against Ms. Clancy I would suggest does not rise to the level under Rule 25 of where even if you take the Lattimore standard and determine that the evidence would be decided in the light most favorable to the government at this stage of the case, I think the Brunette-Silvera case places, as they describe it, a negative obligation to prove a negative as part of their case in chief on the government. I suggest to Your Honor that the evidence that has been presented in this case is overwhelming, that this young woman was clearly and unequivocally suffering from a mental disease or defect, that it was occupying her waking hours, her life, that she considered all of her avenues. She attempted to go to these health care providers, using the term loosely, that she went to these people. She had medication after medication after medication. She was obviously acting, I suggest to the court, in a state that was observed by witnesses that, in fact, that she was suffering from mental disease or defect, and then ultimately this horrific incident. So under that Brunette-Silvera case, there's no evidence, I suggest, from the government that would rebut the fact that there is evidence of lack of criminal responsibility. So under Brunette-Silvera and the cases that were cited in that opinion, respectfully, I would suggest that a required finding of not guilty should be entered on the case. The matter should be reduced down, if you will, from premeditated malice of forethought, cruelty, and atrocity to second degree. I'm not arguing at this stage Commonwealth versus Gray or any of its progeny as to manslaughter, but I think the court, certainly in its wise exercise of discretion, has the ability and the right to reduce the charge to second degree murder or enter a required finding.
All right, counsel, thank you.
Because that's what you do when you're thinking about appeal before the verdict has even been reached. It's chess, not checkers.
Turned down.
Well, I had an opportunity to take a look at Brunette-Silvera. Based on that and based on the standard as described that I have to apply at this point, I'm going to deny the defense.
Then came the witnesses. And this is where the defense's strategy really started to show its teeth. They didn't lead with doctors. They led with people who
at Mass
loved her.
Gen Hospital.
In the years that you were working with her, were you able to observe, I mean, did she like being a nurse? Did she want to work, or was she a good nurse? What's your opinion?
Lindsay loved being a nurse. She was really good at being a nurse. She was compassionate. She was kind. She was a patient advocate. She was the type of nurse that you wanted taking care of you or your loved one when you walked onto our unit.
Did you observe, for example, that on occasion when she would be involved with the delivery of a baby, that she would become emotional?
Lindsay was often emotional during birth of complete strangers. She would cry and she would just say that was so beautiful. You could just tell that she really loved being in that setting.
Hamp testified that Lindsay was very caring for both her patients and her own children.
So Lindsay and I worked the night shift together, and often on the night shift you get to have an opportunity to really get to know your coworkers and celebrate things that are happening in their lives or support them with things that are not going so well. Lindsay asked a lot of questions of her coworkers about parenting. Simple things as she would poll the nursing staff about monogrammed lunch boxes, right down to sleeping habits. What questions do you ask a daycare provider to make sure that you're in the right place? She was often asking her coworkers childcare, parenting tips. Lindsay often checked in on her kids while they were sleeping at night. Again, we worked the night shift, and she had the ability to look at her phone and see what Cora or Callan were doing in their cribs, and she shared that with a lot of us. There was one particular night that Cora was crying. She was probably about 6 months old, and Lindsay never let Cora cry. She wasn't at that point in parenting, and she was very communicative about that. And Cora was crying on the monitor. It was the middle of the night, and maybe after 10 minutes, she started to call Pat, and he wasn't answering. And she got really worried that one, Cora was crying, but now Pat wasn't answering his phone. So in the middle of the night, she called the police to do a wellness check on her family.
This witness also touched on another case, one that Lindsay.
A former coworker described a woman who cried during other people's deliveries because childbirth moved her that much, a nurse who obsessively checked the baby monitor at 3 a.m., a mother who once called the police for a wellness check because her husband wasn't answering his phone and her daughter was crying. This is a woman the defense wants you to understand who is not indifferent to her children. She was consumed by them, to the point of anxiety, to the point of paranoia. And that reframe is deliberate because the prosecution's entire theory depends on painting premeditation. You don't get premeditation from a mother who's terrified something might happen to her kids while she's asleep. Then the walls started closing in on the timeline. A text message to her mother in October, "I'm really sick. Something is wrong. I just don't know how I'm going to get through the day."
Reporter. No.
Lindsay's mom also testified for the defense, saying it was Lindsay's dream to be a mother, but that she saw a shift in Lindsay after the birth of Callan.
I noticed that she had become very anxious. She told me she was anxious about going back to work because Callan was having trouble taking a bottle and she didn't feel right about leaving him.
On October 20th, 2022, Lindsay sent her mother this text.
Mom, will you please come up and stay with me for a bit? I'm really sick. Something is wrong. I had horrible insomnia all night, and I just don't know how I'm going to get through the day. I started taking the medicine my doctor prescribed for anxiety, and I think it's made things worse. It's just really scary.
A mother-in-law testifying that by late November, Lindsay was too afraid to sleep alone and crawled into bed beside her.
Susan Clancy.
Yeah, Lindsay married my son Patrick, and we had a very good relationship.
And obviously, you and your husband were the grandparents of the 3 little kids.
Yes.
And how was your relationship with the babies?
Beautiful.
And tell us how frequently, to your memory, you were able to visit with your son, Lindsay, and of course your grandchildren.
At least a couple times a month we would see them.
Sue Clancy essentially gave a glowing review for Lindsay as a mom.
Can you tell the jurors about how you saw her acting with her children as a mother?
She was very nurturing, very loving. She was a wonderful mother. Wonderful.
Did you ever see her treat her middle son, Dawson, bad because you didn't like him?
No.
Did she love Dawson, in your opinion?
She loved her children, all of them, very, very much.
A sister describing daily suicidal ideation for an entire month straight, and most damning of all, 2 separate calls to a suicide hotline.
On redirect, Sue Clancy testified to Lindsay calling a suicide hotline multiple times, something that's going to come up again later.
She asked you about options that were available to Lindsay, correct?
Yes.
And you mentioned one of them was that she could go to the Women and Infants program in Rhode Island that specializes in perinatal and postpartum, right?
Yes.
You know that she went there, right?
Correct.
You know she was turned away because she was over-medicated, right?
Yes.
You also know that they gave her numbers to call suicide hotlines, right?
Yes.
She called twice, not once, but twice, and again was turned away. Isn't that right?
Turned away both times. A visit to a specialized perinatal psychiatric program in Rhode Island. Turned away for being over-medicated. Sit with that for a second. A trained nurse, someone who understood the healthcare system from the inside, reached out for help through every channel available to her, and every single door closed.
Now, as that time went on into the period of Thanksgiving up to around Christmas, did she continue to reach out to people for help, such as suicide hotlines?
Yes, she reached out to.
The answer is yes.
Yes.
Why did she call a suicide hotline?
She was worried about killing herself.
And did she get any help from the suicide hotline?
She was turned away.
How about the second time she called the suicide hotline?
She was turned away.
How about when she went to the Women and Infants program in Rhode Island?
They told her she was not a good fit for the program.
Why?
Because she was overly medicated.
And did she continue to seek help from healthcare providers?
Yes.
The defense expert testified that Lindsay tried to get help but was turned away multiple times. And while she didn't report hearing voices, she reported on other concerning things.
She felt that her brain was damaged. She felt that she should kill herself. And she's never going to get any better.
Did she also express fear that people could hear her thoughts and that anything adverse would happen in her life regarding being a mother and having children?
Yes, that's called thought broadcasting.
And what was her concern about the children?
Her concern was that when people could hear her thoughts, her children would be removed from her.
If you're the defense, you don't need to argue insanity in the abstract. You just need the jury to ask themselves what happens to a person the system keeps failing. But the prosecution isn't sitting back and letting that narrative breathe unchallenged. Their cross-examinations have been surgical and at times brutal. They pressed a nurse practitioner witness on assumptions she couldn't back up with medical evidence. You keep saying you're sure. You're not sure, are you? You're assuming. They forced a forensic pathologist into a corner over a 13, footfall that supposedly left no visible head injury, no swelling.
You keep saying you're sure there were bruises, that you're sure that there was this or that that's not shown in any photographs or medical evidence. So you're not sure, are you? You're assuming.
No, I'm sure.
Okay. Let me show you some photographs here.
Excuse me. No,
No,
yeah.
and let me show you. I'm asking the questions. Let me show you some photographs
okay, go
here.
ahead.
Let me show you some photographs of the defendant that were taken at the hospital of her head. Show me. Do we have sharing privileges on the computer?
I mean, whatever you want, we'll do it.
Showing you here a photo of the top of the defendant's head. No
Yes, I see that.
cuts, no swelling, correct?
We just see her hair.
There's no blood on the white sheet, correct?
Well, I'm sorry, I couldn't hear what you just asked me.
There's no blood on that very white sheet, correct?
Well, I don't see what's under her head, but that's not relevant to understanding that she did fall head first.
Okay, so you're saying she fell head first from 13 feet onto hard frozen ground and had no visible injuries to the exterior of her head?
Yes.
And
I'm
you're
sure
saying that
there were
she...
excuse me, I'm
It was
sure
a yes
there
or no
was some
question,
bruise.
doctor.
Listen, hold on. Doctor, listen to the question, answer the question, and then we'll just go from there. Go ahead. Ms. Sprague, if you want, Ms. Sprague, if you want to re-ask that question.
Doctor, yes or no, she fell to the ground, frozen ground, and then had no apparent injury to the exterior of her head, correct?
Correct.
Noble hammering the same yes, or no question until the witness had nowhere
Even
left to
starts
go.
crying. Later, ADA Jen Sprague demonstrates with actual exercise bands from an evidence bag.
Showing you the band, doctor. Wrapped around the child's neck several times and then left there. I guess you can't see it from where you are, but it just fell
No,
apart.
I
It didn't stay in a circle.
Yeah, I sort of saw what you did, so
What was that?
I said, I saw that.
You saw it. So it was left there and it fell apart, correct?
Yeah, what you just did.
And they went after the defense's own psychiatric expert on conflict of interest, invoking the actual professional guidelines that say a treating therapist should never also serve as a forensic evaluator, because objectivity dies the moment those two roles collide.
They even suggested that Dr. Zeisel may have possible confirmation bias.
Given that she's my patient, yes, I wrote she was my patient. That's correct.
And you're aware of, again, the APA guidelines on forensic psychology, where it warns therapeutic forensic role conflicts. Providing forensic and therapeutic psychological services to the same individual involves multiple relationships that may impair objectivity and or cause exploitation or other harm. You're aware of that, section 4.02?
Yes.
And in this particular case, since the beginning, you've appeared regularly in court hearings, right?
Yes.
You've appeared with Attorney Reddington at arraignment proceedings,
At his request, yes.
both here and at Tewksbury State Hospital, where you were sitting next to the defendant.
Yes.
And you're aware of the danger of this idea of confirmation bias of having multiple relationships and conflicts in this type of work, correct?
Yes.
And that's why it's important not to be treating somebody as a patient when you're also evaluating them for this type of legal issue, right?
Of course, you cannot be the therapist and the examiner. The therapist is an advocate. The examiner looks for the truth.
That's the chess match. Move, countermove, precision on both sides. And it was working right up until the prosecutor questioning Lindsay's former mother-in-law pivoted without warning.
Now, are you an active member in the Catholic Church?
Yes.
So you're aware that murder is considered a mortal sin?
Counsel, could I see you over here?
After a sidebar, jurors were instructed.
All right. And what that means is you are not to consider it for any reason or any purpose. Okay?
Are you an active member of the Catholic Church? Yes. So you're aware that murder is considered a mortal sin. Before the witness could even process the question, before the word sin had finished landing in the room, Reddington was on his feet. Sidebar. Immediate. The judge struck the question and instructed the jury to disregard it entirely, to erase it from their minds like it never happened. Except it did happen. And here's the problem every trial attorney knows and never says out loud you cannot unring a bell. You can strike a question from the transcript. You cannot strike it from 12 human brains that just heard a defendant's own former mother in law confirm under oath that murder violates her deepest religious conviction. That's not a legal argument. That's not evidence. That's a match dropped next to gasoline, and everyone in that room knew exactly what it was designed to do. Plant guilt, morality, and judgment in a case that is supposed to be decided purely on mental state, not sin. Was it a mistake? A calculated risk that didn't pay off? Or exactly the kind of move a prosecutor makes when they sense the jury drifting towards sympathy and they need a jolt? Consequences be damned. We may never get a straight answer. But we do know this, it's the kind of moment that doesn't stay contained to a courtroom. It becomes the headline. It becomes the clip everyone replays. And it reveals something uncomfortable about how these cases actually get decided. Not just on statutes and burden of proof, but on whatever managed to slip past the objection before the gavel came down. The Commonwealth still has to prove Lindsay Clancy was sane. The defense still has to convince 12 strangers that a woman who begged for help and was turned away again and again wasn't a killer in the legal sense.
Right?
Yes.
And this leads into the medical testimony. The defense called an emergency medicine doctor who actually treated Lindsay after her suicide attempt. His testimony went to undermine the prosecution's potential theory that Lindsay didn't really want to go through with this suicide attempt.
Now, in your experience for a number of years in the emergency room, have you had occasion to treat people that have tried to commit suicide or successfully committed suicide by cutting their throat?
Multiple times.
Multiple times. And can you tell us, in your opinion, to a reasonable degree of medical certainty, sir, as to whether or not this injury or these injuries that you observe were consistent with what you've seen in other suicide attempts?
Sustained.
Well, can you tell us, did that look like an effort to pretend or fake a suicide?
Sustained.
Well, when you looked at the injuries, did you make a determination that they appeared to have some impact on the human body of Ms. Clancy?
Yes.
What was that?
They were consistent with self-injurious behavior. The intent, I can't gauge, but...
He testified Lindsay showed no signs of hesitation wounds.
How about the wrist? What did you observe about the wrist injuries, sir?
So she had 2 full-thickness lacerations, one on the left, one on the right.
What does that mean?
Means that she made it all the way through the epidermis and the dermis, which is what makes up the skin in the wrist, and into the fatty tissue, which is the next layer.
Okay. Are you familiar in your experience, sir, with hesitation wounds in a suicide attempt?
Yes, to some extent.
What does that mean?
Means typically that they're more kind of subtle, weaker attempts to hurt yourself, not necessarily anything that's going to be deep to the structures of the skin, but more just scrapes along the surface.
Okay, and you noticed some of those on the neck area as well, is that correct?
There were multiple of those on both the neck and the wrists.
As it relates to the injuries to the wrists, did you observe any vascular structures or penetration of the cervical, the fascia?
There was not.
Okay.
She was a casualty of a system that failed at every single checkpoint.
The truth.
On redirect, jurors heard for the first time what Lindsay's life is like now, how she reacts to what she's done.
I didn't hear that she's laughing and partying and having a good time while she's in the Tewksbury Hospital. Did you see anything like that?
No, Lindsay Clancy has bad days and worse days.
And when you speak with her and meet with her, doctor, has she ever mentioned her children? Because apparently, according to the questioning that you underwent, she never talks about her kids.
She does speak about her children.
What does she say?
She really loves them and misses them and thinks of them every single day.
Both of those things can be true at once, and that tension is exactly why this case refuses to give anyone an easy, comfortable answer. So now it's your turn. Do you think that question was a genuine misstep or a calculated gamble to plant something the jury was never supposed to hear? Drop your verdict in the comments, hit subscribe if you want to be there when this jury finally decides, and I'll see you in the next one